Okay, in this video I want to talk about the rule of law. Most people will accept that the rule of law is a good idea, it's a good concept, it's a good principle to organise society in a civilised way. The rule of law is widely accepted internationally, but it's never really been defined as such. There's no statutory definition of what the rule of law is. So in this video I want to look at how the rule of law, or the concept or principle of the rule of law, has evolved and exactly what it means. Essentially, everybody recognises that it's analogous to the notion of good, and everyone is for it, but have contrasting different views about what it actually is. There's a famous legal, or professor of law rather, from I think Oxford University called Professor Dicey, and he had three broad principles, three broad characteristics for the rule of law in explaining it. So he says, one, in the first place, no man is punishable or can lawfully be made to suffer in body or goods except for a distinct breach of law established in the ordinary legal manner before the ordinary courts of the land. So you cannot be punished or to made suffer unless you have been found to be in breach of the law before the ordinary courts of the land, whether that's England or the United States or Ireland. His second meaning, Diceys' second meaning of the rule of law, he says, when we speak of the rule of law as a characteristic of our country, not only that with us no man is above the law, but every man, whatever his rank or condition, is subject to the ordinary law of the realm and amenable to the jurisdiction of the ordinary tribunals. In other words, no matter whether you are a prince or a pauper, regardless of where you are on the social spectrum, nobody, no person is above the law. And thirdly, Dicey said, and this is a sort of a racist view, but he said there remains yet a third and different sense in which the rule of law, or the predominance of the legal spirit, may be described as a special attribute of English institutions. That's what Dicey said. That was a special attribute of English institutions. That's clearly nonsense. It is bordering on racist, because the rule of law is widely applied everywhere, or not everywhere in the world, but right across the world, without borders necessarily defining where it can be accepted and applied and so on. There's a strong international consensus then that the rule of law is a meaningful concept and an extremely important one. However, there is a recognition that the definition of the rule of law for inclusion in any statute is difficult and hasn't really happened to date. There's a number of principles, however. The core principle is that all persons and authorities within a state, whether public or private, should be bound by and entitled to the benefit of laws publicly made, taking effect in the future, and publicly administered in the courts. Secondly, the law must be accessible and understandable, clear and predictable. Questions of legal right and liability should ordinarily be resolved by application of the law and not the exercise of discretion. So that doesn't mean that judges or officials or decision makers cannot exercise discretion, but the exercise of discretion cannot be unconstrained as to be potentially arbitrary. So no discretion may be legally unfettered. The laws of the land should apply equally to all, save to the extent that objective differences justify differentiation. That may well be the case, for example, in a situation where there's positive discrimination in favour of somebody perhaps with a disability in accessing work and promotion and opportunity in the workforce and so on. But by and large, the laws of the land should apply equally to all. Ministers and public officers at all levels must exercise the powers conferred on them in good faith, fairly, for the purpose for which the powers were conferred, without exceeding the limits of such powers and not unreasonably. That's where the whole question of judicial review arises. The law must afford adequate protection of fundamental human rights. The rule of law requires that fundamental rights, such as the freedom of belief and practice, should be protected, but it does not require that they should be absolute. We've seen that in Ireland. We have seen the conflict or the clash between the right to assemble, the right to publish stuff, the right to protest, versus the obligation on the government, on the state rather, to bring in laws for the likes of COVID-19 and so on. So rights are not absolute. My right to my good name will clash with your right to freedom of expression, freedom of publication, and there will be always some healthy tension there between rights, between competing rights. Means must be provided for resolving, without prohibitive cost or inordinate delay, bona fide civil disputes which the parties themselves are unable to resolve. Adjudicative procedures provided by the state should be fair, and the rule of law requires compliance by the state with its obligations in international law as in national law. So the rule of law is something that is generally accepted as a good thing, and it would have all of the characteristics that I've just mentioned there now. Historical milestones then in arriving at an idea of the rule of law goes back centuries. It goes back to the Magna Carta of 1215. It goes back to habeas corpus, the idea to challenge unlawful detention, the legal entitlement to do so. It goes back to the abolition of torture, the Petition of Rights from 1628. Then there was Chief Justice of the King's Bench, Sir Matthew Hale, his resolutions. These are all the founding stones or the stepping stones on the way to an understanding and an acceptance of the rule of law. The Habeas Corpus Amendment Act 1679, the Bill of Rights 1689 and Act of Settlement 1701, the Constitution of the United States of America, the French Declaration of the Rights of Man and the Citizen 1789, the American Bill of Rights, the Law of War, the Universal Declaration of Human Rights. These are the stepping stones. These are the steps on the ladder, as it were, which has arrived at and given us this concept, this idea of the rule of law. We all, most of us, accept that the rule of law must be recognised because it makes for the organisation of society in a way that we can all be treated fairly and treated lawfully and treated with a degree of respect, and we have rights and we are entitled to enforce those rights and so on. The rule of law obviously will give rise then to the question of civil disobedience. What is it permissible to, what laws is it permissible to breach, to ignore? Can we take an a la carte approach to laws? Can we choose which laws we like and which laws we don't like? The rule of law is a concept, it's a principle that is vital in my view and in the view of international states and so on to the good functioning of society and the protection of liberties, the protection of rights for all of us. Anyway, I hope you have a better understanding now of what the rule of law is. It is a general sort of a principle. It is widely accepted. There's no statutory definition as such, but the principles and the characteristics, the features that I've referred to in this video are what you'd associate with the rule of law. Hope you find the video useful. If you do, I'd appreciate if you gave it the thumbs up down below, and you may be interested in subscribing to my YouTube channel.